Okay, good morning, distinguished ladies and gentlemen. Apologies for starting late. Palu has extended our ending time because of the delay. Thank you so much to each and every one of you for joining our discussion this morning. We look forward to a fruitful discussion. Our panel this morning is talking about the notable developments in arbitration, and I'm excited that we have a panel of extremely accomplished discussants who I'm going to briefly introduce. Obviously, they are extremely accomplished in their various practice areas, but for the sake of our discussion this morning, I'll briefly talk about who they are, what they do, and really what they enjoy doing. So on my immediate right, I have Dr. Peter Maynard, who's a King's Counsel and is a senior partner at Peter D. Maynard, Counsel and Attorneys, and is president of the Commonwealth Lawyers Association. Dr. Maynard is highly regarded in the fields of international commercial arbitration, litigation, and asset tracing and recovery. He has practiced for 44 years as an arbitrator and arbitration counsel, and is the founder of the ADR Investment Summit, formerly known as the Arbitration and Investment Summit, Caribbean, Latin America, and other emerging markets. His bio includes commercial litigation, chair of the International and Western Hemisphere Arbitration, Adjudication, and Mediation Center. He's the former member of the Latin American and Caribbean Council of the London Court of International Arbitration. He's a fellow and former chair of the Bahamas branch of the Chartered Institute of Arbitrators, and so presiding and party-appointed arbitrator, counsel or advisor in domestic and international commercial arbitrations relating to, among other things, banking, construction, financial services, hotels, labor, maritime, provident funds, resorts, tourism, and trusts. He's also a University of the Bahamas professor of arbitration. Now, despite having such an industrious career, Dr. Maynard is a father of three boys, and recently celebrated 50 years of marriage on 2nd of June, 2023 with his beautiful wife. Thank you so much, Dr. Maynard, for joining us. We also have with us a very accomplished attorney, Mr. Franklin Kose. He's an accomplished advocate qualified to practice in Kenya, renowned for expertise in dispute resolution and investment law. With a profound knowledge base, Franklin holds a distinguished Master's in Law degree from the esteemed Queen Mary University of London. Franklin's focus revolves around intricate realms of international commercial arbitration and investor-state arbitration. Franklin is also a respected mediator interested by Kenya's judiciary to facilitate mediation processes in various domains, including commercial, employment, family, and civil divisions of the courts. Recognized for his scholarly contributions, he has made notable appearances in peer-reviewed regional and global publications and books. His insightful work has graced esteemed platforms such as the Sports Law Review, where he has been a recurring contributor since 2017. In addition, he has shared his expertise on commercial arbitration in Kenya in the highly esteemed Global Arbitration Review. Outside of his industrious law practice, Franklin is an avid traveler, to the extent that when coming to Livingstone, he flew into Lusaka and drove his way from Lusaka to Livingstone, enjoying the beautiful scenery between Lusaka and Livingstone. Franklin, we are so honored and privileged to have you this morning. We look forward to hearing your views on notable developments. And lastly, we have our very own extremely accomplished and successful James Banda, who is from Zambia. We are really honored to have you on our panel this morning. James is currently chairman of the Chartered Institute of Arbitrators of Zambia, Chartered Institute of Arbitrators, Zambia branch. James is the past president of the Law Association of Zambia and past president of the SADC Lawyers Association. He is a former council member of the International Bar Association. He holds a master's law degree in construction and dispute resolution and a Bachelor of Laws degree. He is advocate of all superior courts in Zambia. He is a fellow of the Chartered Institute of Arbitrators. James also serves as a commissioner of the Small Claims Court in Zambia and is a member of the Dispute Resolution Board Foundation, the Society of Construction Law, and the Federation of Consulting Engineers. James has held several appointments as arbitrator on various large-scale domestic and international commercial disputes. His practice involves advising and representing parties in domestic and international arbitrations, adjudications, and court proceedings. His clients include international and local employers, contractors, and consultants in engineering, construction, energy, mining, and information technology projects. Thank you so much, James. Despite having a very illustrious legal practice, we might be interested to learn that James is an avid livestock farmer and meat processor. Outside of practice, he enjoys traveling, sightseeing, and he told me that he keeps all memories of his various escapades around the world in his mind, which is amazing. So thank you so much, James. We look forward to hearing from you in this discussion. Our discussion this morning is about the notable developments in arbitration. And we will discuss this topic in light of the general theme of this conference, which is the sovereign debt crisis and the role of legal practitioners in the same. I'll start with Franklin. Please just tell us what these notable developments in arbitration from your perspective are.
Thank you very much, Irene. I will focus on two main developments in the area of arbitration, particularly in Africa. And the first notable stop would be the recently enacted
sorry, distinguished ladies and gentlemen, we are informed by Secretariat that our learned colleagues who are depending on the French translation are not able to get us. In that regard, we kindly request for your patience, just 5 minutes, so that this technological challenge is looked into. Thank you so much. Over to you, Franklin.
Thank you, Irene. So I will deal with one notable development in arbitration in Africa, particularly the recently enacted Arbitration Act of Nigeria. What is interesting about this act is that for the first time we see the provision and allowance of third-party funding in arbitrations in Africa. Generally, third-party fundings is where, while two parties have a dispute in an arbitration, a separate private party altogether chooses to invest its resources to finance the dispute with the hope that upon determination, they will recoup the investment. This is a very common practice in the USA, particularly in their domestic practice in public interest litigation. And so for the first time, we see this come in Africa to the sense that it is being legislated. It is also interesting because it comes at the backdrop of many domestic laws in Africa, which provide for provisions against champarty and third-party funding. Because for a long time, the understanding in disputes has been that parties, people should not benefit from litigation or from such disputes. But in this case, we see this happening. In terms of what this presents to lawyers and the legal profession, there is now possibly an avenue for law firms and lawyers to invest in cases. I have seen this in the US very commonly for law firms to invest in a dispute and then inflate the intended award to be given and then have that as a source of income. And seeing how this is going to work in Nigeria, possibly this might be replicated in different jurisdictions, and we hope to see how that will play in the legal profession.
Thank you, Franklin. I'll hand over the mic to James to just also give us the notable developments in arbitration. You have about 6 minutes.
Thank you very much, Irene. And good morning, colleagues. The one item I would like to highlight with respect to Zambia is the formation of the Lusaka International Arbitration Center this year. The center is a purely private initiative. It was an initiative which was moved by the Law Association, the Chartered Institute of Arbitrators Zambia branch, the various professional bodies in Zambia, including the Engineering Institute of Zambia, the architects, the bankers, and then also there is involvement of the various chambers, the Zambia Chamber of Commerce and all its affiliates in the various cities in Zambia. Add to that, at the launch, obviously, we're quite deliberate on what we want to see or who we want to see involved in the center. And as you would know, government is a major player in the dispute field. And so we did invite government to the launch. They have indicated their support to use the center as a form of resolving disputes. That obviously will entail quite a lot of work in terms of how government contracts are drafted to incorporate a dispute resolution clause, which will involve the use of LIAC, as we call it. We've seen interest as well from foreign governments as represented by their various embassies in Zambia. We're in discussion with the various embassies. Obviously, the foreign governments have got their citizens, either private citizens or businesses, investing in Zambia. And so a big point for that investment is assurance that the dispute mechanism proceedings are clear and predictable, and arbitration obviously is a choice for such businesses because of the advantages arbitration offers. So there is a discussion with foreign entities in that regard to see how they too can be part of this process. The center will obviously administer the three main ADR processes: arbitration, mediation, and adjudication. So we expect that there will be panels in that regard to deal with all those processes, both a domestic and an international panel. Now, that's where obviously for you practitioners, colleagues, there might be interest in. The center is at its infancy. We have developed already model clauses, which should be going out to the various constituent members of the center and to other players outside this jurisdiction to use and incorporate in their contracts. Rules have been developed at an advanced stage for arbitration, mediation, and adjudication, and we should be concluding them, I think, at the end of this month. But the one thing which we've already done is to develop the arbitration, the model arbitration clauses, model mediation clauses, and even sector-specific, like banking. We've targeted, say, for instance, banks. There are certain items, certain disputes which really should not grace courts, as you would agree. The one argument which we always talk about is, an example which we always talk about is a mortgage. When you borrow money and you default, what is your defense? The defense is whatever your lawyer will craft, that is usually a very shaky defense. Because the issue is that you borrowed and you need to pay back. So when you appear before a judge, usually the issues would be a reconciliation issue. No real argument as to the facts, but simply reconciling the numbers. And we feel those are issues really which should be dealt with at mediation, where experts in reconciling figures are appointed as third-party neutrals to help the parties come up with what the correct amounts are which are due. And so that's what we are targeting at. And the opportunity available, obviously, if an institution is at its infancy, is for you, colleagues, to find yourselves on these panels. It's not a center for Zambia only, it's an international center. And so there's open invitation to everybody who feel qualified to either be on the international panel or the domestic panel. And the criteria, obviously, will be rolled out. It's no different from what you've seen already in the domestic field or on the international field. We will talk about this at some stage on why or where we need to be to find ourselves on these panels. I believe those of you who are interested, before you leave this conference, you can register your interest at the Law Association of Zambia desk, and the center will be in touch with you to tell you how you can find yourselves on this row. So that's one item which I thought I should highlight as a notable development in this region. But outside Zambia, speaking of SADC, if I may, Madam Moderator, there is also what we call the SADC panel. This is something which is being done between, it's a collaboration between the SADC Lawyers Association and the Arbitration Foundation of Southern Africa, AFSA. A panel has been created which was on the recommendation of your various bars. So most of this information, or more of this information, you can obtain from the various bar associations in the SADC region as to how you can find yourself on this panel. Now, why is it that we're talking about this issue of centers, LIAC, AFSA, or SADC panel? The issue, obviously, which arises is there's always a question as to whether disputes which are arising in Africa, lots of disputes which are arising in Africa, why are they not being settled here? Why are they being exported elsewhere? That's the question which arises. And the response we always get is that Africa is not a safe seat. This is not a safe place to arbitrate disputes. We will obviously talk more about these things, but in line with that, one notable dispute issue which has arisen in this jurisdiction in Zambia related to the seat. Those of you who practice in Zambia, you might be interested in the case of ZCCM Holdings versus Vedanta Holdings. It's an appeal which was decided this year. Now, the issues around this is basically what is the response of the courts to arbitration? Are they supportive or not supportive? Generally, I'm not too sure how things are in your various jurisdictions. Generally in Zambia, whenever a contract shows up which has a dispute clause, the courts will routinely refer those to arbitration. Challenges would arise perhaps where the government has got substantial interest in the matter. And the matter goes firstly at the first tier, whether it's the High Court or whatever courts you have in your jurisdictions at the first tier. This case dealt with an investment in one of the biggest mines in the world, where government has a substantial interest. And there was a dispute between the shareholders. When the matter went to the High Court, the investor obviously raised the issue of arbitration, that the matter be referred to arbitration. The High Court did not agree and kept the matter within the courts. In the process, a lot of things happened. The investor then decided to invoke the arbitration clause in Johannesburg, and the arbitration proceeded. And in the process, the arbitrator made certain decisions related to the dispute between the shareholders. Meantime, the matter here in the courts was moving through the appeal stages and finally arrived in the Supreme Court. So what the Supreme Court decided this year in March, the parties argued before the court that the issues which are before the Supreme Court have actually already been dealt with by the arbitral tribunal in Johannesburg. The Supreme Court agreed and said we will actually not even deal with these issues at all because there is an arbitration clause and the issues have been correctly dealt with by the arbitral tribunal in Johannesburg, and therefore we have no jurisdiction to deal with these issues. So this is the decision which is reigning now supreme by the Supreme Court of Zambia, showing that this argument which has been presented several times that Africa is not a safe seat because of court interference in these processes is absolutely not correct. And I know certain decisions in many of African courts have made similar decisions agreeing that when there's an arbitration clause, courts should only interfere when they're allowed to do so. They should actually not interfere at all, but only intervene when they're asked to do so and if it's in clear circumstances. So perhaps, you have stories as well you might want to share with us during this session. But those are the 3 points which I thought I should highlight.
Thank you so much, Franklin and James, for your extremely insightful deliberations. I'll now call upon Dr. Maynard to just give us a global perspective. Where are we in terms of notable developments in arbitration from a global perspective? Dr. Maynard.
Good morning, everybody. I like the quote from Nelson Mandela. It's always seems impossible until it's done. And that seems to be applicable in the context of the theme of this conference, sovereign debt restructuring and forgiveness. A theme I'd like to touch on perhaps is not strictly on arbitration, but the notion that we now should take a more holistic approach to dispute avoidance and dispute management as a whole. And arbitration is a component of that, yes. And in that connection, the Singapore Mediation Convention is an important new development, allowing for the automatic enforcement of mediation settlements. And indeed, in the context of the Commonwealth Lawyers Association, we have gone from country to country, including Zambia now, to encourage more acceptance of the Mediation Convention. I have present with me the honorary life president of the CLA, Santan. If Santan would wave his hand, seated here. I have a job for just 1 year, but he has a job for a lifetime. And we, in our ADR committee of the CLA, have promoted the Singapore Mediation Convention. And before it was, of course, the New York Convention on the automatic enforcement of arbitral awards of 1958 is one of the most successful treaties. And so the point I make is that we need to look at this as a whole. The question of dispute avoidance, dispute management, how to nip a dispute in the bud. And I think that brings me to the next theme, and that is the role that lawyers have to play in the process. We have been talking yesterday about how huge the sovereign debt costs are. Apparently $63 billion paid annually across the continent to serve sovereign debt. And so one has to look for more innovative ways for lawyers to become engaged in the process. Arbitration is one of them, perhaps, dispute settlement as a whole. We know that the lawyers are involved in the beginning, the making of the contract, involved at the end in the debt process, and also very much so in between. And so in terms of governance, there are really 5 themes I think one should be mindful of, and those are transparency. If these agreements were to see the light of day, and often they don't see the light of day at the outset, perhaps some of these difficulties might be avoided. We might avoid the disputes, as I was mentioning earlier. Accountability and sustainability. Obviously, sustainability is suffering in this context. Innovation and some degree of flexibility. We've seen in the context of the Paris meeting just recently, which concluded, I think, last Friday, that debt forgiveness was not particularly successful in that context. I believe the outset was that the French president suggested imposing taxes on maritime transactions and on financial transactions, but not a great deal of progress in terms of debt forgiveness. And so, indeed, hopefully lawyers become more engaged, and perhaps we can be more innovative. Indeed, lawyers need to be proactive in this area, working along with civil society. A multifaceted approach is required. James mentioned something which I also want to touch on, and that is the growth of centers. I happen to be the chair of the International and Western Hemisphere Arbitration, Adjudication, and Mediation Center. And I've seen, I did a study 2 decades ago, and then again a decade ago, and the number has really mushroomed of centers. I also have the honor of being the founder director of the summit, which has now celebrated 11 years, and hopefully the centers you mentioned, James, will become a part of this to explore our commonalities. Because I think we'll be all in our individual silos, but in the diaspora, for example, we have the same concern. And I'm from the Bahamas, that there is a focus on the mother country, so to speak, when it comes to arbitration, the colonial. And whereas many of the disputes can be settled and resolved in our local jurisdictions, or at least even among our jurisdictions. If it may not take place in Zambia, perhaps it could take place in the Bahamas instead of going north, because we now have the expertise in the various areas. And so, just to begin with, those are some things I'd like to mention as developments. That this area of dispute management, dispute avoidance, is changing very rapidly. That it's becoming developed in many countries globally, and to some extent we don't see and share what's happening in other jurisdictions, we ought to do so, to work together, collaborate together, because there'll be a lot of benefit in that kind of collaboration. And also the mediation, lots of developments there to progress this whole idea of dispute management, dispute settlement, dispute avoidance.
Thank you so much, Dr. Maynard. I'll pose a quick question to you in light of the global perspective that you have just given us. With the springing up of international centers, as you have observed, what is it that can be done to make them viable and sustainable? Thank you. 5 minutes.
Well, for one thing, as I mentioned, they ought to collaborate, work together. Not all centers are created equal. Hopefully, they will attract very well-established, skilled dispute resolution specialists. And I think, in the end, there is a great emphasis on domestic resolution, but in terms of international resolution, you probably will have to find out that many will come out in the wash as being stronger in some areas than others. It's very much in a fluid state at the moment, and that's something that we, over the past 11 years, have tried to come to grips with, and we're continuing to do so. There was a ADR, an investment summit, Asia and other emerging markets, which took place last year, and hopefully by the end of the year, there will be one covering, early next year, one covering Africa. And so I think we need to work together, collaborate, explore our commonalities, identify which ones may be stronger in some areas. For example, the Bahamas is a financial center. It may be very strong in financial matters. Zambia is a producer of raw materials. That may be an area for Zambia. And so that kind of thing, we can begin to identify and hopefully collaborate. Competition is not always positive, but it can be positive in many ways. And so we need to explore those commonalities.
Thank you so much. In 2 minutes, James and Franklin, what opportunities are there for lawyers in light of the notable developments?
So with respect to the, like I mentioned, the Arbitration Act of Nigeria, there is, like I mentioned initially, an opportunity for lawyers in the field of investing in disputes and then profiting from said disputes. And I think I want to leave it there.
So firstly, I would like to agree with what Dr. Maynard has said, and the need for the centers to collaborate. So the example he gave on, look at what the country is focused on. Zambia is a big exporter of copper. And cognizant of that, part of the creators or founding members of the center is the Zambia Chamber of Mines, which deals with all the copper producers, all the mining houses, and they've been very instrumental in guiding on how things related to mining disputes ought to be done. And so I agree that there's need for collaboration in that regard, and if centers can focus on what where they'll be able to produce skilled people to deal with disputes related to that particular area, then that might be helpful going forward. Of course, these centers will also help in addressing the issue of domestic disputes which might arise in the various fields. Now, what opportunities are there? I mean, the first thing we have to remember, colleagues, is that this field of ADR requires you to be highly skilled. We can't just show up and hope that things will work. You can't simply pick up a mining dispute and say, this is a contract. I've learned contract law at university and I've dealt with a number of contracts, and therefore I'm capable of handling this. That can't work. It doesn't work like that. First of all, I'm sure you will agree, to even get an appointment, a proper appointment in an arbitration, even in a domestic arbitration, the parties have to be confident that you know what you are doing. And therefore, we can't be, content with sticking at associate level. We need to keep moving up and specializing in specific areas where you feel you are competent. And there are various views. So those are opportunities. This conference is talking about sovereign debt. For government lawyers, obviously, those of you who work with government, you will be involved in negotiations and drafting, reviewing of these agreements. Not all of us are competent in this field. These are very sophisticated agreements. Now, the opportunity for you there is obviously to upskill in that regard and help your respective governments when dealing with contracts like this. You need to be noticeable that you are somebody who knows these things. You can only be noticeable if you do certain things, deliberate things. For instance, write an article or speak at a conference about these things, and people will know that this person knows what he's talking about. So you're creating an opportunity for yourself. And like that, you build up your career. Should a dispute in future arise and you've got the correct credentials and you're on a correct panel, that dispute, people will consider you to handle that dispute. But it requires serious effort on our part. Outside sovereign debt, there are several other issues where we need specialized training and where we can properly place ourselves going forward. One area I could speak about with confidently is in construction. Africa is very behind in infrastructure. So there will be a lot of construction going forward. With construction comes disputes, lots of disputes from the beginning to the end. One thing which Dr. Maynard was talking about is dispute avoidance. That's something which is being emphasized in construction, how to avoid a dispute. The popular forms of contracts for construction, which are used in many African jurisdictions, will be the FIDIC contracts. The latest versions being the 2017 ones, which were updated last year, December last year. In there, the dispute resolution clause refers to, prior to 2017, it referred to what are called disputes adjudication boards. Basically, disputes arises, you see it, you deal with it. Now, it's talking about dispute avoidance and adjudication boards. So you deal with both. You're appointed right at the beginning of the project, and you follow the project through its life, and you know what's going on, and you help the parties avoid those disputes. Should a dispute arise, then you are better placed to help the parties to resolve that dispute. So that is what is happening and moving rapidly in the disputes world. The point, we need to upskill and place ourselves. When these things arise, then we are available to handle such disputes.
Thank you, James. Thank you, Franklin. We'll move on to the African Continental Free Trade Area Agreement and its protocols, particularly the protocol on rules and procedures on the settlement of disputes. In light of the notable developments that we have talked about and various other aspects of arbitration, Franklin, what would be your comment?
Thank you, Irene. Now, with respect to the African Free Continental Trade Area, or simply the agreement, I want to have some discussions around the same. Because of time, I will focus specifically on the protocol on rules and procedure with respect to settlement of disputes under the agreement. Generally speaking, the agreement was concluded in 30th May of 2019, but only came into effect on the 1st of January 2021, at the point where 25 countries ratified the agreement. As we speak today, out of a total of 54 parties who have signed the agreement, 46 have ratified the same, which basically means 82% uptake of the agreement. Given the age of the agreement, this is commendable. However, and which is also quite disturbing, in as much as we have this very beautiful agreement, to date there has not been any trade or any dispute arising from the said agreement. So that yet, like in many other situations, as Africa, we have a very beautiful agreement, we have a very beautiful framework, but not yet utilized. And this is not to say that there has not been any trade between countries. In fact, there has been, but just not within the context of that agreement. And I will deal later on, those issues and those challenges. I want to talk about the protocol on the rules and on rules and procedure on settlement of disputes within the agreement. It provides for three, it gives different mechanisms for settlement of disputes. For the purpose of our discussion today, I will focus on arbitration. And under its provision for arbitration, it gives three mechanisms for settlement of disputes. The first is a body known as the dispute settlement body. The dispute settlement body is a body that is comprised of a representative from each of the members. So that now we have 46 members in that dispute settlement body. It is basically the umbrella body that looks into disputes whenever they arise. In the event that a dispute arises, it is charged with the mandate of appointing and constituting a panel, right? So you have to remember it in this sense, and this also will come as some of the possible pitfalls. So we have a body made up of states. If a dispute arises, it would be a dispute between states, and it is states who then appoint a panel. Now, this could play out as a good thing in the sense that the best panel could be appointed, but it could also play out in the sense that if I'm from Kenya, if we have a dispute, we collude with some of our friends and then appoint into the panel a panel that we feel is beneficial to us. So we haven't seen this in practice yet, but I anticipate that that is going to be an issue that will come. Secondly, and this has been mentioned by Mr. Banda and Dr. Maynard, we have a body called the adjudication panel. The adjudication panel is slightly different from the panel that would be constituted in the initial dispute settlement body. The adjudication panel, which is a bit different from the adjudication that we understand in construction disputes. In this case, the adjudication panel is made up of experts in the relevant fields. As it is now, it is made up of 7 persons who are experts in international law and international trade law. Its purpose generally is to adjudicate disputes whenever they arise. And as we all know, adjudication basically is a means to try and contain the dispute before it becomes a fully fledged dispute altogether. Usually, this happens in the course of the contract. In many instances, in an arbitration, the contract might be concluded or terminated. In an adjudication setting, it is possible, and so in the agreement, it is possible to deal with a dispute and still, proceed with the obligations and the functioning of that agreement. This panel is also compromised by, of course, like I mentioned, states. In this case, each state provides 2 people who sit in the panel and then who then determine who the 7 experts would be. And of course, this also presents the initial challenge that I had indicated, which is the question of impartiality or otherwise of that panel. Lastly, we have the appellate body. The appellate body is in charge of any appeals that may arise from the dispute settlement body or the adjudication body. But it goes further. Even if there is no appeal, the appellate body is in charge of reviewing the decisions and changing them if necessary. We have seen this replicated in other different centers, particularly the Singapore Center for International Arbitration. But the model used in this agreement is a bit, so to say, too much in the sense that they have power to amend, including the substantive findings of that decision. Of course, this has not happened yet, but that's something that we want to see how that would work. In other jurisdictions, such as Singapore, while we have a body that would look into awards and determinations, their role is limited to the extent that it cannot determine or change substantive findings or computations of awards. But in this case, we see a very powerful appellate body that has the power to change and review awards. But in any case, so once an award has been given, it is sent back to the whole General Assembly of the dispute settlement body, which then ratifies or agrees with the award, and at that point it becomes final and binding. But at the same time, there are some parallel or alternative provisions for settlement of disputes within the agreement. One is settlement of the agreement through the Secretary General, which basically embraces mediation and conciliation. And I think this would be really a good way to go, in the sense that if a dispute should arise, parties can agree and say, look, instead of going through the arbitration, let's go to the Secretary General. He can appoint a mediator or a conciliator, and that mediator or conciliator then helps the parties in dealing with a dispute. This is not mentioned, but I think it is not in the Act, but I think it's worth mentioning, and it has arisen from the discussions from the panel. The Act does not provide for dispute avoidance mechanism or body, but I think moving forward, there should be consideration and thought about including this panel as well, so that we, like Dr. Maynard mentioned, we capture the dispute well in advance and hopefully avoid it. Lastly, on this question of the agreement, I want to talk briefly about possible pitfalls that we think would come once the Act and the rules are operationalized. And the biggest, as you can imagine, is that, look, at the end of the day, the parties to the agreement are states. So then what happens to private investors, right? We feel, especially given the theme of the conference, private acts and private investors are a big deal and very influential in dealing with the economy and the problem that we have in Kenya, because they bring a lot of foreign direct investment, so from whichever country. But this agreement, and possibly why it has not yet been had any active cases, is because it locks out private investors from lodging a dispute within that agreement or from benefiting within its framework. Of course, this is a similar situation with the World Trade Organization dispute resolution settlement or mechanism. But what the WTO has done is that it has allowed for states to bring disputes on behalf of their nationals or on behalf of their citizens. So, for instance, if there is a dispute between, say, Turkey and Israel regarding some mining, but a company from Israel, under the WTO, Israel can effectively represent their national or their citizen or the company from the host company in this arbitration. And we feel that moving forward, in as much as that is a lacuna, this could be a possible way around it. Alternatively, under the ICSID convention, we have under Article 27 a provision for diplomatic protection. Diplomatic protection generally is an arrangement where in investor states dispute, a country can take to an arbitral tribunal a dispute which is really from its own company. So, for instance, if Zambia has a big company here in the field of mining and it falls into a dispute with another country, under the doctrine of diplomatic protection, it is allowed to present that dispute. And we think that while this is a pitfall, we think as practitioners that it is possible to go around it. Secondly, and this is a big one, African states are really not keen on having disputes with each other. So if there's a dispute between Zambia and Malawi, they would rather send their ministers to talk and then come up with a behind-the-door meeting of sorts in the spirit of diplomacy. And this is also a pitfall, because then it not only creates a lot of question marks in some instances, but it also denies us of the benefit of having to benefit from the jurisprudence that would come as a result of this agreement. Thirdly, we have very readily available alternatives, and this really is hopefully one thing that as Africans we need to think about. So that in the event of a dispute, people are very happy to go to the London Center for International Arbitration or to go to the ICC, right? And we were having this discussion earlier. If you have foreign clans in whichever country, they would prefer to go to Hong Kong or whichever country, in as much as a dispute was concluded here, so as a contract. And so this really is a challenge that we need to deal with. And then lastly, states feel that there are practical areas of disagreement within the act itself, within the agreement itself. For instance, every country is a member of a regional economic cooperation. For instance, I come from Kenya, so we have the East African Community. And we have our own ways. We have a very robust and functioning East African Community Justice Court. We have our own harmonized systems of trade and tariffs and taxes. Now, some of the provisions in the agreement, this African agreement, contradicts with the provisions of the EAC. And that can be replicated across board, across SADC and all. And so states have the sense that if we submit our disputes to this agreement, then, I mean, you know, it is a bit confusing because already they feel comfortable, they feel like they already operational and functioning mechanisms are effectively predictable, and states want that. So that would be it for now in terms of the agreement.
Thank you very much, Franklin. Dr. Maynard, our theme at this conference is the sovereign debt crisis and the role of lawyers. The question to you and to the rest of the discussants in 5 minutes each is arbitration playing a robust role in managing the debt crisis or even resolving it, if one has to say?
In dealing with the debt crisis, one has to take a multifaceted approach. The lawyer's role may be at the initial resolution or the establishment of the contract, the very beginning, whether it has clauses involved which may obviate, avoid the problem. For example, James mentioned the Dispute Avoidance and Adjudication Board. It happens that in another silo, this is news to me, but in other areas, we also have Dispute Avoidance and Adjudication Boards. And that's, again, a benefit of collaborating. In fact, I was the draftsman of a bill which was presented to the Bahamas government. Bahamas government is very big in tourism. Tourism is 60% of the economy, 8 million tourists. Population of 400,000, but 8 million tourists a year. And 8,000 people were out of work on a particular resort like this, came to a halt. And actually there was an arbitration clause which was not properly observed. But the investor met with the government at the beginning, as they would presumably in Zambia, and they concluded heads of agreement. And so the new bill places the notion that there should be dispute avoidance and management boards for projects such as that. But at the initial stage of the formation of the heads of agreement, that there be some dispute avoidance process introduced. In other words, instead of ending up with 8,000 people out of work because the owner doesn't get along with the contractors for some reason or another, that mechanism avoids the dispute at an early stage and could have avoided the loss of 8,000 jobs. And so there is room there for the lawyer to come into play, and if necessary, to go to the stage of arbitration. I think one should look at it as sort of multi-stage process. You've got the consultations, negotiations, you've got the mediation, and if that doesn't work, then let's get to arbitration as quickly as possible. And so I think this is a dynamic and changing landscape, particularly in countries such as our own. And arbitration can play a greater role at the beginning in terms of the overall framework. We need to be more innovative, more proactive. We need to make sure that those frameworks are implemented. For example, as Franklin mentioned, and I read the protocol again last night. It's a beautiful protocol, very well drafted. But we need to make sure they're implemented. We also need to make sure there's transparency, because a lot of this stuff is done behind closed doors. And if it's on the light of day, perhaps civil society could step in and take remedial action at an early stage. And that engages lawyers. And of course, it may involve arbitration, it may not. But should be looked at in an overall dispute avoidance and management context.
Thank you, Dr. Maynard. Franklin, 5 minutes.
Thank you again, Irene. So certainly I think as lawyers we play a role in the theme of this conference. And you know, sometimes I once was with a friend and he said, you know, when I think of lawyers, it's very difficult to tell what lawyers do. Because if you are with a civil engineer, he will tell you I built this road. A structural engineer will tell you I did this structure. A doctor will say I healed you. A teacher will say, you know, this is a student I've taught. But as lawyers, if I look at you, I mean, most of what you do is in the mind or in documents, and many non-lawyers will not understand. Coming here today, my cab driver was like, you know, what do you lawyers do in these conferences? You know, he can't understand why it's a big deal that you know we are here. Because the services that you provide are very soft and intangible. And usually they make sense to us, you know, and not to non-lawyers. But I certainly think that we have a role to play. Dr. Maynard has mentioned a few, but I just want to briefly highlight. But I think as lawyers, especially dispute resolution lawyers, we have a role in correctly advising our states on the question of prevention. We have had, as countries, situations where our countries have been involved in disputes, and because, you know, lawyers benefit from disputes going on, they would rather proceed with the dispute, lose, but, you know, just proceed with it. But I think as lawyers, we have an obligation to correctly advise our states, and also influence domestic policies on the question of, you know, actively thinking and doing and leaving the question of preventing disputes. I also think so I'm an avid mediator, and I feel that there is a big room for mediation in this context. You see, as opposed to an arbitration or litigation where the relationship is completely broken, in the instance that Dr. Maynard has mentioned, in mediation we are able to retain the relationships way after the dispute has been determined. And so I think as lawyers we could also benefit to this end by championing mediation, and maybe combined with that adjudication, so that you know, I believe that as lawyers we are in the business of helping our clients do their business. Now, if when you step in as lawyers and everything goes down the drain, even if we win, I feel that we have lost the bigger picture, because we should try and come up with a situation whereby, yes, let's have this dispute, but let's continue working. Okay, this is quite evident in adjudication, especially construction adjudication, given the nature. But I think as lawyers we can champion for this and hopefully have that possibility. And then I think lastly, just influence domestic policies, try and provide for actively countries to think about these things, and ultimately have a culture of, you know, at the end of the day, let's have a dispute, but let's remember what is at the bottom line, or what is really at the back of our minds. And I think I'll pass the microphone to Mr. Banda.
Thank you. I think I agree with my colleagues. We play a role in influencing policy. The debt, most governments is governed by laws. The bar associations where we come from are, in most instances, creatures of statute with mandates to advise governments. That's our mandate. It's a legal mandate to advise them. So that includes on these issues of sovereign debt. mostly we're where we are because these things are done, there's no transparency around these things. And that is a problem. But we consistently need to speak out. We know that these things are happening, so we need to speak out. It starts with the contracts. How are these contracts entered into? Who are the lawyers who advise the politicians before these contracts are signed? The attorney generals in the various jurisdictions will be instrumental in this. But does he have people under him who are skilled and understand what needs to be in a proper contract, including the dispute clause? Whereas what we have seen in the various jurisdictions is that when the governments agree with funders from wherever, they'll focus on the main issue, the money items in the contract, and nobody will read the dispute clause. The only time that will be read is when the dispute arises, and then you find yourself wherever, ICC, Hong Kong, wherever, and that's the problem. So people need to know that these things need to be done well in advance, because where the money comes from, they will read these things thoroughly, and they will have a team of professionals looking at these things. We need this from our side, and the skill is here. If we are not in government, we can be active in our bar associations and frequently talk about these things with our colleagues in government, even at the highest level, to advise why this is important, because it affects us all. That's why we're talking about it now. And so, yes, I agree with Dr. Maynard that, in dealing with these things, maybe a tiered approach will be helpful. You can't straight go to arbitration. You could incorporate mediation and agree in instances like these, which institutions will be able to handle a matter involving the various parties, the states and the funders, to help mediate these neutral institutions, not institutions which also have an interest and get us nowhere and take us back in the same vicious cycle. But these are issues which must be debated properly. And to debate them properly, we have to be knowledgeable. I go back to this point. We have to be knowledgeable about what is in issue. What do our laws say about governments contracting debt? What is involved? Who is going to be party to these discussions? That way, we'll have an influence on what is happening and not discussing the problem when it has arisen and is affecting us all.
Sorry, Irene, allow me to just mention something very quickly that has come to mind after Mr. Bwanda's presentation. And I think that as lawyers, we should and could also champion for keeping our disputes local. There's a famous African saying, usually with a wrong connotation, but it says, this is Africa and Africa is our business, But I think we can also say that for disputes, in the sense that whenever disputes arises in Africa, we should, as much as possible, keep them within Africa. Like Mr. Bwanda has mentioned, usually we call arbitration clauses midnight clauses. The rationale being that, once you draft the whole substantive agreement, you're like, oh, sorry, we need a dispute resolution agreement, and then you copy and paste something from the internet at midnight. So usually the phrase is midnight clauses. But I think if we are a bit more intentional about the wordings of the midnight clauses, the choice of seats of the arbitration, and even the place, then would go a long way to keeping the disputes local, because we understand the African needs, we understand the peculiar arrangements here. Of course, many times when you have these international agreements, other powers would insist that this must be handled in Hong Kong or in whichever country that the other party is from. But I think as lawyers, we have that obligation to ensure that those disputes are handled locally.
Thank you so much. Lastly, from our panel, we would like to tackle the issue of AI, artificial intelligence. On 26 June 2023, as we may be aware, the United Nations passed a universal declaration on the fair use of artificial intelligence, especially by lawyers. So it contains the rules of ethics, ethical considerations that ought to be considered when using artificial intelligence. The question to you, panelists, is, in your view, do you see artificial intelligence as a threat to arbitration? We have heard that in some countries like China, they do have apps that are able to predict the outcome of disputes, be it in mediation, be it in arbitration, be it in a courtroom setup, a dispute adjudicated by a judge in court. And there's been an outcry somehow that artificial intelligence is out to make lawyers jobless in a way. So is artificial intelligence a threat to arbitration? You have 2 minutes each so that we can now take comments and questions from our audience. Thank you, Dr. Maynard.
A very interesting question. AI, you may have seen the story of the American attorney who produced an opinion for the judge in the course of the argument. And he quoted a number of cases, say 3 or 4 cases, in support of his argument. The judge went away and could not find any reports of the cases. And he asked the lawyer to produce reports, and the lawyer couldn't find any reports either. And it turned out that ChatGPT had totally fictionalized the entire account. That's the challenge to some extent, with AI and ChatGPT. It's not particularly reliable. If any of you have used it recently, you'll notice that they now have put a disclaimer at the end that we're giving you this material, but it may be entirely fictionalized, maybe total fiction. But however, there are apps, as you mentioned, which can be helpful. I think it's a tool that can be helpful. Indeed, some apps claim that they can conduct your arbitration for you. They can be your arbitrator, so to speak. That's an interesting development. We use keywords when we go into law databases to find something. Likewise, nowadays we need to use case sentences, more complex sentences. That capacity is expanded very dramatically through the use of AI. But still one has to check the reliability of it to make sure that it doesn't replace you, but I tell, for example, students. Students produce something in arbitration, for example, and one can't now tell whether it's ChatGPT or whether it's the student's work. And so they actually somebody says the solution is to produce the essay, put it into ChatGPT, and ask ChatGPT, did you write this essay of the student? But someone came up with a bright idea that they could produce an app from the product of ChatGPT to disguise it so that ChatGPT won't recognize it anymore. And so there are many different levels. And the only solution really is to make sure, I think, that the student is in front of you in person and you see the student's performance. You see the student produce the work, unfortunately. And so AI brings with it lots of benefits, but one has to use it very discreetly. It doesn't replace lawyers. Lawyers may have a different role. Perhaps it's a powerful tool, but still we have to be able to check its reliability.
So this is a favorite topic to me. Possibly because I'm also the youngest in the panel and we are technologically savvy. My thoughts about AI is that I think it cuts both ways. I look at AI as a knife. because with a knife you could cut your fingers, or with a knife you could, cut your vegetables. I don't know whether you heard of this story where there was an AI in England which sat for a master's program and passed, and even did a dissertation and passed, just to show how complex and how advanced these AI technologies and languages can be. When I look at AI, I look at it in terms of different facets, and these are ways that we can use them as lawyers. Of course, we cannot assume that it will not catch up with us as dispute resolution practitioners. We have seen it recently catch up with our brothers in the conveyancing departments and in the corporate and commercial departments. Because now if a client comes to you, several years ago a client would walk in and say, please give me a contract. Now a client goes on to ChatGPT, puts in all the things that they want from the contract, and gets a perfectly sound contract with some minor amendments here and there. So I think, in a sense, it has caught up with our brothers, and I think it is also coming for us in the dispute resolution scheme. So in terms of research, it is a good thing in the sense that it is not entirely bad, because through ChatGPT, for instance, you could get very good researches. Of course, not entirely thought through, but it will basically give you pointers to where you need to go in your research, because it has a wide base of information. We also could use AI in the sense of using it as a predictive mechanism. We have firms in the US which have invested heavily in AI. So the AI has consolidated a lot of decisions and awards and determinations, and it has analyzed them so that when a client walks into that law firm and says, this is my dispute, they can go into the AI, feed it the facts as accurate as possible, and it will tell you, given the facts that you have supplied, there is a high chance that this will be the finding. So, of course, this in the interim is not a bad thing for lawyers. I mean, if you have such a thing, regardless of where you stand, of course, as disputes, we can argue the same facts, the same law, and as 2 or 5 separate lawyers, 5 separate positions. So I don't think there will ever be a time when every dispute resolution lawyer agrees on a particular point, especially when you have clients, paying the bills. But of course, as lawyers, that kind of investment would give you an indication as to what to look out for, what are the possible chances of success, and what are the areas to tweak. And so in that sense, it is not entirely a bad thing. It could also, in fact, possibly for Mr. Banda and such centers, centers could consider investing in this kind of database and research, so that when a person walks in as a paid service, or even as an arbitrator, you run the facts in the AI language, and it tells you these are the possible things to look at. But this goes to what Irene also mentioned on the ethics around it. There has been discussions in other jurisdictions where a lawyer should disclose and say, on these issues, I relied on AI. Okay, but of course, these are ethical situations and challenges that we want to see how they'll play out. But generally, I think that as lawyers, we need to think about it, particularly as dispute resolution lawyers. We need to think about it. We need to be alive to the fact that it's coming, maybe not now, but certainly in 10 years. And I feel that if we think about it, we can always find a way to benefit from it. In my country, we do a lot of tea plantations, and now we have a big problem because we have very large tea plantations which employs thousands of employees. But then we have a machine which can do, say a machine can do work of 1,000 people in several hours, 1,000 man hours in several hours. And so really it is a moral question. The government has had to pass some resolution saying, no, we cannot use machines. Even if they're supposed to be used, they cannot use in the hope of securing their businesses. But we don't have that kind of protection as lawyers, and so we need to think about it, and think about it in the sense of how can we benefit, because I think there are many areas to benefit from AI.
Yeah, I see some worried faces in the room. Lots of conservatives in the room. But if you recall when the COVID hit, colleagues, those of you who are active in sitting as arbitrators, we did postpone quite a number of hearings in the hope that things will normalize. And they didn't. 3 years we had the COVID. And we quickly adapted to online hearings. and became proficient in using Zoom, Teams, and how to access documents, thousands of documents online. We dealt with, all kinds of software in handling court arbitration documents, and it works, and it continues to work. Even when things have normalized, we're quite comfortable in proceeding virtually, because as arbitration is supposed to do, that has helped in cutting down costs. So we embrace that change, and we are quite happy to proceed that way. This thing is here, this AI thing is here, and I can't predict whether it will take over arbitration and render us jobless. I don't know, but like with everything else new, we need to move with the times, embrace it, use it ethically, as my colleagues here have said. I met somebody at the airport yesterday who was talking about ChatGPT. I've heard of it, but it was fully explained to me yesterday because we're doing a transaction with this colleague of mine, and they're saying, well, it took them a microsecond to do the documents. So it's being used even in our jurisdiction. I haven't heard of any arbitrator who has used AI to predict or to help him write the award. I don't know. It would be nice to hear from you, colleagues. But if something can help you achieve what we have set out to do with ADR, reduce on cost and time, we should be thinking about it, so long as we use it ethically. I think that's my take.
Thank you so much. We'll now take questions and comments from the audience. If there are any questions, comments, okay. We'll start with 3 questions. I'll start with my learned sister there, and I saw a hand behind my brother there, and then we can have our lifetime president then give us a question. Please, you can proceed.
Good morning. Thank you very much for all these interesting contributions. My name is Lilian Moteli. I would like to...
Thank you.
Thank you. I have a question that concerns one aspect that you mentioned about the fact that most of the disputes are treated in the global north and not necessarily here on the African continent. And I would like to understand why, what are the reasons behind this displacement of the disputes. And also, I would like to understand how it affects the capacity of African actors to defend their interest in those disputes. Thank you.
Good morning. My name is Kenneth Wilson. I practice with MMC Asafo, based in Kenya. My question is to Mr. James Banda. Do you think that the seat of arbitration and applicable laws are usually overlooked when drafting of arbitration clauses? Thank you.
Good morning. I am Santana Krishnan. I am a lawyer based in Delhi, practicing in the Supreme Court of India. My question is a general question with regard to the statements that were made by our panelists. One catchword that caught my attention is collaboration. I heard collaboration being initiated in Zambia at some regional levels. My question is whether there is any collaboration efforts made pan-Africa. Maybe the moderator can answer me, representing Palu or anybody else. Thank you.
We'll first address the 3 questions and then take Okay. There's a question directed to James. He'll tackle that one. Then there's a question on why disputes are resolved outside Africa. I'll let Franklin answer that. And then on collaboration, I'll let Dr. Maynard answer that. So, James, you can take up your question.
I think, Kenneth, your question was whether the seat and applicable rules are overlooked when drafting clauses. Applicable laws. Right. So when you're talking about the seat, you're basically talking about the what is the juridical law applicable? What is the law which you apply to the arbitration? Simplest example I can give is if you say the seat is Zambia, then it's the Arbitration Act of Zambia which will be applicable. Okay? That's the Arbitration Act number 19 of 2000. That's the law which will apply. And it's important to specify the seat because whatever assistance you need regarding that arbitration, it's the courts in Zambia which will determine. If you need, something to do with witnesses to be compelled to attend, or even the setting aside proceedings, it's the courts in Zambia which will deal with that. That's the importance of the seat. When you talk about the applicable law, it can be three things. Firstly, the seat, the arbitration law or the lex arbitri. It can be the law of the contract. What's the applicable law of the contract? Or what will be, and the third thing would be the rules. So to break that down, let me give you again a simple example. When the arbitration clause says the seat will be Zambia, the applicable law of the contract will be South Africa, and the rules would be the Chartered Institute of Arbitration Zambia rules. We're talking about three things. All that can be the applicable law, but these are things which you as you learn your arbitration, you learn about and learn to distinguish as you grow in your practice. So seat, you're talking about the applicable law to that arbitration, which will govern the processes, which can include appointment of the arbitral tribunal and setting aside. Okay? Rules. How many days do you have to file in your statements of claims, stuff like that? Those will be rules which you can decide as parties. The Chartered Institute of Arbitrators or ICC rules or whichever rules from wherever. And then the applicable law will be already have been dealt with in the contract. The parties can say, for this contract, in interpreting it, the tribunal will refer to South African law. So those are the various categories. Are those things overlooked? Most times they are overlooked, and that creates a problem. An arbitration clause is so important that it even survives, as you know, a termination of a contract. It's got a life of its own. So that is something we really need to pay attention to, but most times we don't. I'm sure somebody will touch on this, but that's how oftentimes we end up finding these disputes elsewhere. If I give you an example of, to take you back to the construction world, the FIDIC contracts state use arbitration as the document, as the mode of the dispute resolution route to take when a dispute arises. And it says the rules applicable will be the ICC rules. And so when a construction dispute arises, you find yourself in Paris and arbitrators being appointed from there. Wherever the venue will be, the ICC will determine, all the parties will agree. But that is in a separate document. It's in the FIDIC general conditions, and nobody maybe will have paid attention to it. So these are things which we need to be alive to when drafting agreements. What is the seat and what is its relevance? Okay, because you want a seat where the courts are supportive and will not interfere in arbitration proceedings. So if you choose a seat which is the courts are problematic and will stop an arbitration proceeding, then you've chosen the wrong seat. So you need to be familiar with the various jurisdictions which are tolerant of arbitration and are supportive. As I gave that example of Zambia, the judges in these jurisdictions are very familiar, from the Chief Justice downwards, with how and to deal with any matters related to arbitration. And the case which I refer to is very cardinal and illustrative of that point. So as practitioners, know the basics which need to be in arbitration clause. And the big issue, one big issue is the seat. And that is usually overlooked. And I'm sure somebody will elaborate as to why in the end we end up where we end up instead of resolving disputes in this continent.
In fact, I'll just pick up on where Mr. Banda has left to the question why disputes are displaced from Africa. Now, there's a famous saying among arbitration circles, and this is, it's a true statement, that an arbitration is, the quality of an arbitration is as good as the arbitrator, okay? So people proceed with that understanding. Like Mr. Banda has mentioned, when you think of displacement or even the place of arbitration, we think of three things. We think of the seat, we think of the substantive law, and we think of the rules. Now, rules, like mentioned, rules, you could subscribe to rules for whichever organization. You could choose to have rules of SADC, or you can have the Lusaka rules to apply, or you can even have rules by the Chartered Institute of Arbitrators. So you can pick rules from anywhere. Substantive law would basically be the operational law in terms of looking at the laws and obligations, or obligations and liabilities among parties. So that if we say that the substantive law of Kenya would apply, if the question is a contractual question, then the Contract Act of Kenya would apply with respect to obligations of parties and whatnot, and the same applies across board. But the most important is a question of seat. And I need to distinguish that seat is distinguishable from the physical place of the arbitration. The seat basically means the legal place of the arbitration, which is different from the physical place of the arbitration. An example would be, we could say that the seat of this arbitration is Kigali, Rwanda. But that arbitration necessarily doesn't have to be held in Kigali, Rwanda. It could be held in the Bahamas, it could be held in South Africa, it could even be held virtually. But the seat is in Rwanda. So the relevance of the seat is why people would leave Africa. Because the choice of seat is very important for the following reasons. In choosing a seat, you effectively choose what the procedural laws for the arbitration is, okay? But even more important, in choosing the seat, you're subscribing to the court's intervention within that jurisdiction. So that if I'm subscribing to the seat as Rwanda, Kigali, I will have to go to the Rwandese courts for whichever relief that I want. If I need a witness to be compelled to come to court, if I need production of documents, if I need to go above the arbitrator, I am compelled to go to the domestic courts of Rwanda. Now, many investors or many parties outside the continent would not want to come to African courts for reasons of perceived bias, perceived corruption, and so they would want to go to those other seats in places where they understand. And then, of course, apart from that, there are other issues outside the seat. For instance, clients would insist that they want these arbitrations to be held in their country and whatnot. But like mentioned, most of these things can be dealt with at the point of drafting that arbitration agreement.
Yeah, just to touch on the question of collaboration asked by Sant, I have the same question in my mind to understand the collaboration. Indeed, I know that there are a number of powerhouses in the world of arbitration across Africa. The summit I mentioned earlier, we have the summit for Asia, which took place last year. The summit for Africa, which I hope can be developed, would be meant to nurture and understand that collaboration a lot more. There is I should mention also the Commonwealth Law Conference, which will be held in Malta in 2025. I invite you all to come because they will be discussing these kinds of issues. The last one, the one in 2019 was actually held here in Albany at this very same center. Hosted by Santan. So they collaborate.
this is a start, to recognize that to achieve this, we need to collaborate. If we have that recognition, then, you know, the way to that, that's the quickest response I would give. Could I just say something quickly? Those of you involved in on negotiating teams, you will meet resistance from funders for the seats to be in Africa. That's natural, it will come. So the issue is, the idea is not to insist on your country. That would be a starting point. So the guy from the UK will say London. Me, I will say Lusaka, Zambia. So deadlock. But if we offer alternatives, that has worked. I have one ongoing now. It has ended up in Kigali, because that's the Europeans have seen Kigali is working, and so that has worked. So have an idea of the centers around which you're comfortable with, which your clients will be comfortable with, which your governments will be comfortable with. And then you need to know the rules which those institutions use. Offer those alternatives, and then you might score success there.
Thank you so much. We'll take the last three questions. Last three questions, as we have run out of time. Just there. Yes.
Thank you so much. My name is Driven Kangwa from Zambia. I have a question for the president of the Chartered Institute of Arbitrators, Zambia branch. I wanted to find out what criteria the institute uses to determine who should handle an arbitration dispute in an event that the parties fail to agree on who should arbitrate their dispute. There are certain instances where you feel that the arbitration has to do with the interpretation of a contract. Then on the other end, the other party might feel it needs to do with, it's more on a construction dispute side, so they want to know the valuation of the works and stuff like that. So they'll feel that the best person to handle such a dispute is a quantity surveyor. So I just wanted to find out what criteria the institute uses to determine who should handle an arbitration. Thank you.
Thank you. Second question. I think you had a question, sir. Okay.
Thank you. I thought you... Am I audible? I thought you said questions or comments.
Yes, please, if you have comments, that would be appreciated.
One or two comments. Starting with, I think Africa must know we are involved in an economic war with the rest of the world. The first point of weakness for Africa is if you are bringing in a contractor who is funding you, you dictate the terms. You will say that arbitration will be in France if you want the money. That is where the problem begins. And James was suggesting some way of ameliorating that problem. One of the ways is to insist on at least an arbitrator, a co-arbitrator from your own jurisdiction. This is an economic war, including concerning fees. I've been involved in arbitrations from about 2008, and I've been involved in international arbitrations, at least 4 cases. I'm presently involved in one. It's a closed shop. For you to be appointed as an arbitrator by the ICC and other organizations is an uphill battle. So at least in addition, James, to suggesting that you deal with the seat and whatever, you also should insist as a country, if it is a country contract, at least that one of the arbitrators should be one from your country. Otherwise, we have 3 arbitrators, one from France, one from New Zealand, one from England, and no one understands the issues you are facing. Now, I think the weakness of our bargaining power in economics, that is what dictates the terms. Now, with regard to the seat, I'm involved now in an international arbitration where the seat is Johannesburg. And the substantive law to apply is English, right? Now, you can see the procedural law we are going to use, I think it will be Johannesburg. But the substantive law we are going to use will be English, which means that we will have, should we not agree, or if it did not be obvious, we will have to get experts on English law. It's not a question of you saying, I understand English law, I went to school in England, I practiced there, that is the law. You would have to lead evidence on English law. So there are all these complexities. Now, as I say, to me, unless I'm wrong, the seat determines the procedural law you use. And the substantive law is determined by the provision relating to what law is applicable. Now, courts are supportive. In Zimbabwe, I come from Zimbabwe, we was a judge of the Court of Appeal of Lesotho. I'm a former judge in Zimbabwe. Our courts in Zimbabwe have been very supportive of arbitration. Very supportive. Right from the start, we've had arbitration where we incorporated the Angstrom rules, the United Nations rules, and that has never given us a problem. But distrust of African courts, African arbitrators, is an economic war we are engaged with. So I think we must be very aware. The only area, of course, where our Supreme Court judge in Zimbabwe, Justice Bunu, we can confirm, the courts have been very supportive. Secondly, you only go to the court on grounds of review. You don't go to the court to question the substantive decision of the arbitrator, because the whole thing is contractual. And that is how it has been approached. Now, I'm very happy, of course, that we have a Lusaka International Arbitration Center coming on stream. I suppose, as you said, it has some legislative framework to support it. And also, another key factor is to secure fees for the arbitrators and so on and so on. That has become a problem to some extent, even in international arbitration. You do an arbitration, somehow it's becoming problematic to get the fees. The other development you mentioned were third-party funding.
You have 2 minutes, sir.
Yes, I will. Third-party funding. I am not sure that, is it any different from, that's a question, from the charging of contingency fees? In Zimbabwe, we introduced contingency fees some time ago, where you can support and then get your fees when the person has succeeded. Or if he doesn't succeed, then you don't charge any fees. So anyway, I think, to James, appointment of arbitrators is very important, but it's a closed shop, that I can tell you. It's a very closed shop. Thank you. We could have many more comments, but there we are.
Thank you so much. Before you address the question, I think he raised a question on contingency fees. We'll take the last question from my learned colleague, the lady in red. Just there. Thank you. Thank you, James.
Bonjour à tous. Je m'appelle Babette Songolé. Je suis de la RDC. Alors, je m'adresse à Franklin, qui a parlé des opportunités. Maître Babette Songolé, je suis avocate de la RDC, précisément du barreau du Congo central. Alors, ma question s'adresse à Franklin, qui a parlé des opportunités de l'avocat. J'aimerais savoir, c'est vrai, il y a des opportunités, mais à quoi s'expose l'avocat? Quel est le danger qui découle de ces opportunités? On ne peut pas parler des opportunités sans inconvénients. On ne peut pas parler des opportunités sans risque. Quel est le risque qu'expose l'avocat? Est-ce qu'en se lançant sur ces opportunités, l'avocat se livre à lui-même, ou bien ça sera vraiment bénéfique pour lui? Merci.
Merci. Franklin?
Thank you. I'm not sure whether I understood the question properly from the interpretation, but the question is, what are the risks arising from opportunities that we have talked about? Okay, so I'll just deal very quickly in a split second the question of third-party funding as opposed to contingency fee. A contingency fee is an arrangement where the advocate and the client agrees that possibly I'll just pay you the filing fees and I will not pay you legal fees. But in the event that you succeed, the lawyer gets, say, 30% of the award. Okay? So the fees is contingent on, a percentage contingent on the award that is won. So that is contingency fee. Third-party funding is different in the sense that in a third-party funding, you are involved in, say, a public interest litigation, which requires a lot of resources, a lot of money, a lot of research, and as a small law firm, you have no resources to be able to mount such a case. So a private investor comes and invests in your dispute. So they say, you have this dispute, we think it will cost you $1 million. We're willing to supply you with all that you need in terms of your travel expenses, your research expenses, and any expense that you need, including paying you for that duration. But when you succeed, the award that you get, we get, say, 80% of that award, and you keep 20%. So for them, it's third-party funding in the sense that a third person comes and invests in a dispute and then gets a stake at the award that is finally given to you. And this is very common in the US. Now it is introduced in Nigeria, and we want to see what African states are going to do as a result of that. And then very quickly to the question on the risks as a result of this, opportunities. Of course, I think the first risk is that we may not succeed in most of these proposals that we put through in the sense of dealing with this proposed reforms. I also think that as a risk, particularly with respect to AI, we as lawyers we have the risk of going out of business, because certainly it is an opportunity for us to tap into the field of technology, but that also means that some of lawyers who are left behind will lose out on business. And a good example is 20 years ago, I'm sure, when Dr. Maynard started his practice, they had printers and very different technology. You needed a secretary. Now, as a lawyer, I don't need a secretary to do all that. So one big risk that I see is that lawyers might be left behind in these changes, so that if we don't embrace these technologies and these opportunities, some of us may be left behind.
Thank you. Grover, the criteria used is to look at the arbitration clause and the input from the parties. Sometimes dissatisfaction comes because the clause is not clear enough as to the type of arbitrator you have. So if you can foresee, depending on the type of contract you have done, if you can foresee what possible disputes will arise, if it's a construction dispute, and the likely type of dispute which will arise will be the values in terms of the materials used, a QS would be handy. Okay? If you can't foresee the type of disputes, fine. You would say you need, for this type of, say for instance, a lawyer with training in construction. So it's usually helpful for you to draft the clause in more precise terms as much as you can. If you can't, and this matter comes to the institute for an appointment, the nature of the dispute will be looked at, the arbitration clause will be looked at, and that will help in determining the type of arbitrator to appoint, looking at the available arbitrators on the panel. Those who are already busy with an appointment obviously will not be considered at that particular time. You look at the remaining ones and an appointment, it's done. But again, we go back to the drafting. Try as much as possible to be clear if you can, and that's helpful, because that's the essence of ADR. Party autonomy is very big. It's you to decide who you want to resolve the dispute. Judge, I totally agree with the comments you have raised on the need to be clear who to appoint on arbitral tribunals. If during your negotiations you agree that somebody from each respective country should be on the panel and the two appoint a chairman, great. We've resolved a lot of issues around the panel. So these are skills which we need to learn, how to negotiate these things. Sometimes you don't leave it to an arbitral institution. You simply ask the institution to administer and say, these are the people whom we've chosen, administer this dispute, then they'll handle the fees, etc. The issue about that getting appointments is difficult. It is very difficult, and you could argue, as judges argue, that it seems like it is a closed shop. Yes, it's very categorical that it's a closed shop, but there are opportunities, and you have to seize those opportunities. And you can't get those opportunities if we are at the same level, operating at the same level. If you've done domestic distributions, domestic arbitrations, the game is different at the international level. So you have to up your game. That's the way things work. There's no magic to it. I'm not too sure what other comments to deal with. I've run out of time. Okay.
Merci tout le monde. Thank you everybody for joining us. Thank you to the panelists. It's been a fruitful discussion, and this marks the end of our session.
Thank you, everyone. Just one housekeeping comment. For those who would like to attend the gala dinner and you've not bought your tickets, they are available for sale for only $50 right at the entrance to the main hall. Thank you. No, $50. That was amazing. Yeah, thank you.
Moderating this session. With me here are distinguished legal practitioners, and then I'll briefly introduce them before we proceed. To my left-hand side, we have the distinguished Madam Aisha Boudiaf, the Vice President, Northern Africa of PALU, and also a practicing lawyer, an accomplished practicing lawyer. You're welcome, Ma. Yes, and then to my right-hand side, we have the distinguished Mr. Santan Krishnan. He was born in a middle-class family in 1953 at Hyderabad and pursued his school and college education between the years 1958 and 1976. He obtained a master's degree in economics at Osmania University, Hyderabad. During student days, he organized youth festivals and sports events, and as a student organizer, he founded and headed Young Folks League, a literary club, at Hyderabad. He also organized educational tours and trekking expeditions, subsequently espousing the cause of rule of law as part of the Organization for Protection of Democratic Rights during the years 1975 to 1979. He was briefly employed with the provincial government during 1981 and 87, and was also Secretary of Employees Welfare Association. During the course of employment, he was involved in the work of Election Commission of India from voter enumeration onwards until the completion of poll process, and as an official was part of the democratic process of conduct of general elections. He joined the profession of law during the beginning of 1988, and after practicing in the High Court at Hyderabad for a few years, shifted to the Supreme Court of India at Delhi in 1992. Okay. The translation, please. Okay, it's not. Okay, the translation, please. right, we'll pause for like 5 minutes while the translation is, yes, they've requested for 5 minutes, so we'll pause until it's resolved. We apologize for that, please. So we'll have 5 minutes for language break then, so you interact with your neighbors. The swift action. Hello everyone, may we proceed? Oh. Yes, maybe they change the device. Can you make sure that this is working? This is mine. It's okay. Oh, very well then. May we proceed? Mr. Krishnan was standing counsel of Road Transport Corporation for more than a decade. Practiced mainly in employment and administrative law, and also in human rights, election, arbitration, and constitutional law. As an active member of the bar associations, he assisted in the activity of continuing legal education and the organization of cricket among lawyers. After being elected as president of Indian Advocates Cricket Association in 2002, he started associating with CLA, that's the Commonwealth Lawyers Association, by attending the 2005 Commonwealth Law Conference at London. He organized educational and cricket tour of lawyers from India to various Commonwealth countries like Sri Lanka, England, Trinidad, Barbados, and a host of others. He was co-opted as council member of the Commonwealth Lawyers Association in 2008 as deputy head of the local organizing committee, and he organized the 17th Commonwealth Law Conference at Hyderabad in 2011. Subsequently, in 2013, as part of the 4th LCWC, he hosted a sports law conference in Delhi under the aegis of the Commonwealth Lawyers Association. He was elected as the vice president of the Commonwealth Lawyers Association for a term from 2015 to 2017, and subsequently he became the president from 2017 to 2019. Ladies and gentlemen, we have a sports-inclined panelist on the session. I don't know if you merge mediation and a little bit of sports as well. Yes, so you're welcome, sir. Yes, so we hope to listen to your insightful session. Yes. All right, without further ado, we'll proceed to hear from the panelists for 10 minutes each, after which we'll have a discussion. I will ask them questions, and then we'll receive questions from the audience. So while they're speaking, you can put down your questions and then indicate when I request for questions. Madam Aisha, you have the floor, please.
Bonjour tout le monde. Je suis ravi d'être parmi vous et j'espère que nos interventions vont être instructives pour tout le monde. Alors, nous avons aujourd'hui le thème de la médiation, les moyens alternatifs de règlement des conflits. Quand on va vers ces moyens, nous voyons qu'il y a deux voies, la voie amiable et la voie non amiable. La voie amiable qu'on connaît tous par l'arbitrage et les voies amiables sont la médiation et la conciliation. La conciliation est un moyen selon lequel les parties du conflit tentent de trouver un accord en faisant appel à un tiers appelé la conciliation pour un règlement amiable du conflit. La conciliation consiste donc à tenter de trouver une solution satisfaisante pour les parties, indépendamment des raisons du conflit. Donc, la conciliation, le conciliateur, ne cherche pas à rapprocher les points de vue, mais il doit proposer des solutions acceptables pour les parties. Et ce, contrairement au médiateur, qui lui doit rapprocher les points de vue des parties et il ne doit en aucun cas proposer. Le mode de la conciliation des parties, les parties du conflit ne participent pas à la recherche de solutions avec le conciliateur, contrairement à la médiation. Le conciliateur ne participe pas, il propose juste, il essaye de faire joindre les deux avis des deux parties, mais il les laisse prendre la décision. Par contre, le médiateur, il propose une solution. Les conditions de travail ne sont pas très... Alors, les avantages des modes alternatifs. Nous avons la confidentialité, la rapidité de la procédure de conciliation, le coût qui est raisonnable, et le taux de succès est important, ainsi que le taux d'exécution, qui est aussi important comparativement à l'arbitrage, qui lui coûte très très cher par rapport à la médiation et la conciliation. Donc aujourd'hui, nous allons baser notre médiation, notre thème plutôt, sur la médiation juridictionnelle et la médiation conventionnelle internationale. Nous allons appuyer notre intervention sur la médiation conventionnelle internationale, qui est un processus par lequel les parties tentent de trouver un accord à l'écart de toute procédure judiciaire afin de résoudre le différend qui les oppose en ayant recours à un service d'un tiers de leur choix. La mission donc du médiateur, le médiateur doit être accompli avec impartialité, compétence et diligence pour le règlement amiable du litige découlant d'un rapport de droit, contractuel ou autre. Il est aussi important de souligner que le médiateur n'a pas le pouvoir d'imposer une solution ou une décision, comme nous venons de le dire tout à l'heure, comparativement donc à l'arbitre qui lui rend une décision qui est obligatoire pour les deux parties. Alors, on peut se poser la question, quand on peut considérer que la médiation conventionnelle est internationale. Quand les parties sont des États différents, les parties de la convention de la médiation bien sûr, là il y aura une médiation conventionnelle internationale. Elle est considérée comme étant internationale. Ou bien l'État dans lequel les parties ont un établissement des établissements différents. soit dans un état où une part substantielle des obligations découlant de la relation commerciale doit être exécutée. Là aussi, on considère que la médiation conventionnelle est internationale, ou bien dans l'état où l'objet du litige a le plus d'intérêt. Dans ce cas aussi, la médiation conventionnelle, est internationale. La médiation donc repose sur le CNUD-DETSI. Elle a pour objet d'aider les États à réformer, à moderniser leur législation sur la médiation. Il y a 33 pays donc qui l'ont adoptée. Elle porte essentiellement sur la procédure, la nomination du ou des médiateurs, la durée de la médiation, la conduite de la médiation, la communication entre le ou les médiateurs avec les parties, l'aspect confidentialité et enfin la recevabilité des moyens de preuve. Donc cette loi, LT type, contient des règles uniformes sur l'exécution des accords de règlement en dressant une liste des motifs de refus d'une demande d'exécution. Les clauses du type peuvent prévoir la médiation ou une combinaison médiation-arbitrage. Donc, il revient aux parties de faire un choix, soit qu'ils choisissent uniquement la médiation ou bien faire une combinaison partie arbitrage, partie médiation. Au cas, par exemple, où la médiation n'aboutit pas, on peut aller vers l'arbitrage. Ce qui n'est pas le cas. Quand on choisit l'arbitrage en premier, on ne peut pas aller vers la médiation. Donc, il y a la Convention de Singapour sur les accords internationaux issus de la médiation. Ces accords visés par la Convention doivent observer 3 conditions essentiellement. L'accord de règlement amiable, donc, doit être écrit. L'accord est issu d'un processus de médiation. L'accord de règlement vise à régler un litige commercial à caractère international. Et enfin, pour terminer, on dira que la loi du CNUD-DETSI sur la médiatisation commerciale et les accords de règlement sont compatibles avec la Convention de Singapour. Les États peuvent adopter l'un ou l'autre des 2 instruments, ou les 2 comme volets complémentaires du régime juridique exhaustif de la médiation. Donc, telle a été notre intervention. Bien sûr, ce n'est que en vue du temps qui nous est imparti. On ne pouvait pas toucher à tous les volets donc, de la médiation, des moyens alternatifs pour le règlement des litiges, mais c'est un petit peu un résumé succinct de ce qui est donc d'une manière générale la médiation et la médiation conventionnelle. Je vous remercie.
Thank you very much, Ma, for that insightful presentation. We would move to Mr. Krishnan.
Good afternoon, colleagues from across Africa. First of all, let me start by saying thank you to Palu for giving me the opportunity to share some thoughts with you all. About little more than a year back, I was part of an ADR and investment summit in Asia and emerging markets. Peter, the president of Commonwealth Lawyers Association, and few others, we organized it online. And he has been doing this for more than a decade in Caribbean and the Latin American jurisdictions. Taking advantage of what happened to all of us during COVID, this was organized last year, and a similar attempt is going to be made to organize it in Africa also. But what is important here is we had about 6 sessions in that summit, and the last session was on mediation. We had speakers from every continent across the world, and I was having the privilege of moderating that mediation event. Towards the end, when all the speakers submitted their presentations, I asked a common question to every one of them. And the common question that I asked to every one of them was, today we are talking of mediation, today we are talking of Singapore Convention. And we are saying that all the countries to sign and ratify it. My question was, what happens if every country in this universe both sign as well as ratify the Singapore Convention? Are we all going to witness a different world? By and large, everybody responded not only positively, but in their own way, they expressed their sentiments. If I have to wind up and bring that in one sentence, what they said was, if every country signs and ratifies, it will be a very ideal situation, and all of us will get to see a world where collaboration, peace, and prosperity can be witnessed. So this was the unanimous opinion expressed by all the panelists, and thereafter we took a call and passed a resolution that of all of us, in our own respective ways and means, try to persuade countries from across the world to sign and ratify the Singapore Convention. What I am trying to say is, one of the most notable development that took place in the last few years in the field of mediation is the UN resolution that was adopted in the year 2019 in order to give effect to the settlements arrived at between parties across various jurisdictions. In order to give effect to it, United Nations passed a resolution, and in Singapore it was formally adopted during August 2019. And we have passed about 4 years since then. Initially, about 40 plus countries signed this Convention of Singapore, and thereafter in the last 4 years, the development is we have about 50 plus countries signing it. The latest one being the United Kingdom. United Kingdom was one of the major countries which colonized the world, but when it came to signing and ratifying this convention, they just did it. The reasons for all of us to try to analyze and understand. Traditionally speaking, more so in Africa, before we entered into this arena of adjudication as a method of dispute resolution, what we witnessed was the traditional societies had its own way to resolve the disputes. Amicable way, you can say, few elders of the community, few elders of that particular area coming together to find solutions to various problems that arise within the society. That was a traditional method. Industrial Revolution and post-industrial revolution, we saw commerce being introduced. And when commerce was introduced, when goods were being supplied from within their own respective jurisdictions to various parts across the world, especially who colonized the world, the concept of adjudication was introduced. That is, any kind of dispute, all kinds of disputes will go to the respective courts that were created in the post-colonial world. And in the process of colonizing the entire world, this concept of adjudication as a method for dispute resolution was adopted. Not satisfied with the experience that was there in vogue for more than, say, a couple of centuries, after the Second World War, during the year 1950s, United States came forward with another concept, and that was arbitration. And that's the reason why we saw the New York Convention that was adopted by the United Nations was given formal effect to in New York, and that's why we called it New York Convention. And we started following that, which means the private method of dispute resolution, but whatever happened in the court, by and large the same method, ignoring the procedural aspects for a while, arbitration was adopted. The entire world, every country in this world had their own statutory formation to resolve the dispute through the mechanism of arbitration. And thereafter we start witnessing a situation where even adjudication through the courts, adjudication through arbitration was still not alive to the problems that were there, disputes that were there in existence, and therefore they started thinking afresh. Pursuant to a study conducted, pursuant to experts who were employed to get into this problem and to find solution, and pursuant to their report, United States of America came forward to introduce this concept called mediation. And mediation has been in existence roughly for about 20 years and started off in United States. What I must tell you is, today, in the recent past, a survey was conducted in one of the states in US, probably California, and what they realized is the experience with regard to mediation. Almost more than 90% of the disputes that arose in that jurisdiction, I think California if I'm right, were resolved through the process of mediation. United So by and large, it was United States initiative from there, followed by the Western European countries, which adopted mediation as a mechanism. And you might ask, what is the importance of Singapore and what is the importance of Singapore Convention? United Nations initiative saw a unanimous resolution being passed in the year 2018. We brought mediation into the forefront. Formally it was passed in Singapore, and what is the importance of Singapore? The importance of Singapore, which is unique in its own way, is the legislature, the executive and the judiciary in Singapore, all of them speak in the same language. It is not the case across the world, and uniqueness in Singapore. You have your own experience in Africa. The legislature might think something, the judiciary might think in a different way, and the executive in a totally different way. So it's not easy. That's the reason why Singapore assumes importance, because they led and showed the way as to what is the importance and necessity of having all three bodies thinking alike and executing alike. And that's the reason why we saw Singapore Convention, which is nothing but United Nations Resolution of 2018, formally brought into the fore during August 2019. As I said earlier, about 40 plus countries signed, and today the number has just gone above 50. But what is important is, what happened in the last 4 years? Only 10 have joined. Why others are not in the picture? Because the world is yet to see and understand as to what is the importance of this new way of resolving the dispute. It is totally different from the mindset one has as a lawyer who argues before the court every day, and as a judge who sits and adjudicates every matter. The mindset is totally different. The question that is asked is, who is right and who is wrong? This is what the judge thinks, asks, and finds from the evidence, and then decides to tell us who was right and who was wrong. As a lawyer appearing for different parties, we think the same way. Mediation is totally different. What mediation brought to the table was, what is the interest of these respective parties who are into adjudicating a particular dispute. So the mindset changes. That's the reason why during the earlier session, the speakers were relying on importance of training. That's the reason why it is totally different mindset that is required to be a mediator and to resolve a dispute. In the process of doing this, there is a major shift, which is mindset change, that you get only by way of training. And in that training, whoever emerges as a mediator starts practicing as a mediator, poses different kind of questions to the parties who are in dispute and the lawyers who are espousing the causes of their respective clients. And in this process, without suggesting a solution, driving the parties towards the solution is the approach of mediation. And as I told earlier, the most significant thing is today, the Singapore Convention. About a year back, I was witness to a webinar organized by the Commonwealth Secretariat, the main Commonwealth. The question that was posed in that particular webinar was, traditionally we have delays in courts, number one. Number two, we have been grappling with finding ways and means of dealing with the delays in the respective, the jurisdictions. Today, added to that, we have COVID. Number of the courts across the world is closed, partly operational, partly physically trying to adopt the online methods, etc., etc. How are we going to deal with this situation which has arisen because of COVID? This particular webinar was a 4 or 5 part series concentrating to get speakers on board from various regions of the world. I attended all of them. I heard all of them. What I am trying to share with you is a crux of what all the speakers were speaking. They said 2 things. If I have to cull out everybody's opinion. What are those two things? One, use the technology that is there today. Technology can be useful to us. Earlier session we talked about AI. Use the technology for resolving the disputes that arise from across the world. And that will streamline the administrative justice process and give you a better result. Number two, the most important thing which they said, which unanimous of all the speakers, was mediation. Introduce mediation in all courts across the world, inside the court, outside the court. Whatever is there in existence, let it be there. In addition, there are a number of disputes which can be resolved through mediation. All the disputes that are for adjudication before the court need not be adjudicated at all, excepting few. The issues of constitutional importance, etc., etc. If you leave those, a major chunk of disputes which are pending before the court can be resolved by adopting this method of mediation. So, the 5-part webinar at the initiative of the Commonwealth Secretariat, by and large, the opinion was twofold. One is technology, second is mediation. So, that drives home the point, the importance of mediation, especially in the post-COVID world, when we added to the existing delays that are there while dealing with mediation. So, what is the way out? The way out that emerges, that's a notable significant point, is online mediation. Online mediation is again a different ball game from the mediation as such. We are today dealing with mediation which is physical in nature. Tomorrow, already the practice has started in various jurisdictions. Advanced capitalist countries are doing this online. Again, it is a different mindset that is required, because when the parties are in front of you and when you are confronting them with so many questions, you can see the body language. Try to understand what they are trying to say from the body language. When you see online everything, you cannot understand the same way. When the party, you ask a question to the party, ask the lawyer to keep quiet, and when the party is answering, you see the body language besides whatever the party is telling you, and try to understand, and you will have a better questions, different questions, driving them towards the solution. So online is not easy in that sense, but can we not take advantage of the technology? The answer is yes. There are a number of issues which can be easily resolved without the parties being physically present. In case of, say, motor accidents, the kind of evidence that are there, the entire approach to resolve that, to find as to whether, first of all, whether a compensation can be given, and to what extent a compensation can be given. To resolve this particular dispute, you don't need physical at all, because it's a party concerned versus the insurance company. So you can adopt online method to resolve this. Earlier, Mr. James was pointing out, if you have taken a bank loan and if you have to give the loan back, since you defaulted, the matter is before the court. To resolve this amicably in a particular way, by trying to tell them you can pay these installments in so and so period. Do you need a physical mediation? The answer is no. So online mediation, take advantage of the technology. The entire African continent, with the initiative of PALU, can sit and try to promote this particular online dispute resolution. Since culturally speaking, by and large, you understand each other better than the people who come from outside Africa, this particular method can be adopted. So that is one of the notable developments that we are witness, particularly because of the COVID. COVID pushed us and made us think on these lines for us to take advantage of that and do something in reality. What is important is, I asked a question during the last session. What is the Pan-African Lawyers Union, which represents the entire African continent, is trying to do with regard to reflecting the kind of disputes that are there across the continent and what you call trying to find solutions through the mechanism of arbitration. On the same lines, at Palu's initiative, this can be done by making every one of us think Africa is not a continent, but Africa is a country. I regularly receive a mail on the concept Africa is a country. Just think for a while. If all the 54 countries in Africa come together on one table and try to say, let us all ratify and sign the Singapore Convention, what happens? What happens is, we were talking of trade, we were talking of investment, we were talking of cross-border investments, and consequently, it will also be cross-border disputes resolution. When all the countries across Africa sign and ratify this, Africa in reality can become one country. Today it is there in existence as a concept, and tomorrow that will be a reality. So what needs to be done? We need to promote mediation in our own respective way. Suddenly if you go to somebody and ask them to sign, they will start thinking, why this man has come, why is he asking? We had this recent experience. In Commonwealth Lawyers Association, there is an ADR committee. In the ADR committee, we took a call. The call was to promote Singapore Convention. The idea is to approach all the countries across the world, which is Commonwealth especially, to sign and ratify it so that we can see a better world for tomorrow. Peter, the president of Commonwealth Lawyers Association, was sitting here, and me, we started taking this initiative. We went to Gambia, we went to Trinidad, we went to Guyana, we met the Governor General of Antigua and Barbuda, and today we are here. What's the purpose? The purpose is to tell everybody in Africa through this platform to sign and ratify this convention so that we can see a different world altogether. And as I started by saying, collaboration, peace and prosperity. Before I end, I must tell you, with regard to how do we promote mediation as a concept. In India, I am a convener of an organization called Nivaran, which is Mediators of Supreme Court of India. What we do is, we have been for the 4th year in succession hosting a series of lectures on mediation. It is not, we don't concentrate on the specialized skill that is required on mediation. It is just sharing with everybody as to how mediation came about, what is its history, and how do we introduce the subjects, and what are the various aspects on which mediation can be discussed, thought of, and learned from each other. And towards the end, what we do is, the United Nations SDG, which is nothing but taking and leading the society towards peace. So we do this And this year also we are doing it from 22nd of July to 2nd of August. In terms of cost, there's nothing. It's almost free of cost. All of you plus encourage the youngsters, the next generation, to join and try to see who is trying to share with us what. And that will help all of us in trying to see a different world where the importance is on collaboration, peace, and prosperity. Thanks for this opportunity.
Thank you very much for the thought-provoking presentation. While you were speaking, you mentioned that in mediation, mediators are aimed at the interest of the parties, unlike other methods of resolving disputes. How does artificial intelligence fit into mediation? You know, considering that the artificial intelligence is technology and not a human being who can actually look at the demeanor of the parties, you know, can actually consider the interest of the parties from maybe their body language and probably from their demeanor while they are presenting their cases. So how does artificial intelligence fit? Does artificial intelligence has a place in mediation?
Thanks for the question. What I would say is, technology, artificial intelligence is one part of technology. You can go on expanding that. Today we hear about Chat GPT. However good that might be, it can replace so many things, but it cannot replace a human mind. Maybe one day we come to that situation, we don't know, but I don't think so. As far as I am concerned, a human mind is a human mind. A machine cannot replace a human mind. So what happens is, we are not only alive to the realities of the problems, but there is something called emotion. The emotional connect between one human being with the other, the machines cannot replace human, human emotions. And that's the reason why our ingenuity should be utilize the artificial intelligence, utilize the modern technology, and as discussed, for example, today we have online dispute resolution mechanism. Use artificial intelligence, try to understand what the problem is, and accordingly talk to the parties, the negotiation part in the concept of mediation, where you pose question depending on, number one, your understanding of the problem and your understanding of parties, what exactly they want. So that will be the basis on which you drive the dispute towards solution. So utilize the underlying messages, utilize the artificial intelligence to the best possible manner, apply your own mind, understand the issues, and at the stage of negotiation comes, you put appropriate questions that will drive home towards the solution.
Thank you very much, sir. Madam Aisha, can you shed more light on the effectiveness of mediation, especially in cross-border disputes?
Vous savez, les problèmes transfrontaliers font beaucoup plus partie de situations politiques que d'interventions médiatiques, de médiation. Seulement, nous, quand on voit par exemple les problèmes qu'il y a aux frontières entre, par exemple, l'Algérie, la Libye, le Mali, là, il y a beaucoup, la médiation y est pour beaucoup. beaucoup de choses ont pu être réglées par des médiateurs chevronnés qu'on appelle en politique la diplomatie. Donc, à mon avis, c'est le règlement par les voies donc alternatives des conflits, par la médiation sur le plan frontalier apporte beaucoup plus de bienfaits entre les États que de recourir, car quand il y a réellement un conflit au niveau des frontières, les pays, le moyen le plus facile, c'est de, je n'aime pas cette expression, mais je suis obligé de la donner, prendre les armes. Et là, ça ne mène jamais à une situation, parce que même après la prise des armes, il faut s'asseoir à une table et il faut négocier. Donc, quand il y a négociation, il y a quand même une médiation. Donc, elle est au niveau frontalier, la médiation devrait être privilégiée sur toutes les autres moyens donc, de règlement des conflits. J'espère pouvoir avoir pu répondre à votre question.
Thank you very much, Ma. Yes, you have answered the question. Now, before we hear from the delegates, we would listen to both panelists as they talk about how lawyers can equip themselves to serve the clients better in mediation. So we'll hear from you, Madam, before we move to Mr. Krishnan. How can lawyers equip themselves, especially in light of the, okay? Okay, yes. So how can lawyers equip themselves, especially in light of the contemporary influences, such as the technology, you know? How can lawyers equip themselves to better serve clients in mediation?
Tout d'abord, il faudrait qu'on sache dans le domaine juridique, est-ce que l'avocat peut faire une médiation? Ce n'est pas le cas dans tous les pays. Par exemple, je parle bien sûr de l'Algérie. L'Algérie, l'avocat, quand il y a eu donc la médiation, quand on parlait de médiation, de conciliation et tout ça, l'avocat n'était pas concerné par ce moyen. Seulement, il y a quelque temps, et là, le projet de loi est sur donc, la table de l'APN, de l'Assemblée populaire nationale, pour que l'avocat ait le droit de faire une médiation, on appellera l'avocat médiateur. Et il ne doit pas être, cet avocat médiateur, ne doit pas être l'avocat de l'une des parties. C'est-à-dire que les parties ont déjà des conseillers et ils peuvent choisir un troisième avocat qui, lui, sera médiateur. Donc, auparavant, la médiation, donc je parle bien sûr en Algérie, la conciliation remonte à très très longtemps. D'avant la colonisation et durant la colonisation, la conciliation était entre familles. On pouvait pas, c'était honteux pour les gens d'aller en justice, mais il fallait privilégier les moyens, ces moyens alternatifs aujourd'hui qui sont très très à la mode. Il fallait pour éviter d'aller devant les tribunaux. D'ailleurs, jusqu'à aujourd'hui, dans certaines régions, il est très difficile à des personnes de s'adresser à un tribunal parce que c'est honteux. Comment on peut traduire quelqu'un devant la justice et tout ça? Pourquoi il n'a pas privilégié l'intervention des sages? C'était le conseil des sages avant. Donc voilà, je crois que j'ai fait un petit peu le tour de votre préoccupation.
Yes, thank you very much, Mar. Mr. Krishnan, can you give us your perspective?
The uniqueness of the lawyer's profession is there are various professions that we see in action, but one thing which is unique about a lawyer's profession is you can be part of the societal building process. The uniqueness is you not only serve the individual clients, you also serve the cause through, say, for example, a public interest litigation. You serve the community at large which is affected because of an action or an inaction on part of the establishment. So, lawyers have a very great and unique role to play, and we must have seen this from across various countries in Africa as to how lawyers were there as in the forefront of your freedom struggle or of your, societal affairs by being part of the government or in the opposition, etc., etc. Mediation is one such unique thing where lawyers, in a way, or at least partly, should come out of the mindset of adjudication as a dispute resolution method. First, try to understand by participating in various lectures, webinars, online classes, etc., etc., to understand the concept of mediation, number one, and also get yourself trained as a mediator so that you start looking at interest of the parties instead of asking yourself who is right and who is wrong. And once you first unlearn and then learn this process, you will be better equipped to resolve so many issues that are confronting this world. Besides pre-COVID, during COVID, and post-COVID, the problems have increased multifold. Besides all this, the world today is witnessing climate change. The world is under threat. Since the world's existence itself is under threat, and as I told you earlier, today we are more so in an interdependent world. The most developed country in this world cannot sit in an isolation thinking that I am the best in the world. For anybody and everybody, any problems they have, whatever be the kind of problems they have to come to me. That world is gone. Today, the threat of climate, the most vulnerable are the small islands. And we have seen the voice that has come from Barbados, the Prime Minister, who is espousing the cause of all the island nations. That is only one example. So in this scenario, lawyers have got a major role to play. As I told you, number one, they first do this process of unlearning, changing the mindset, learning, try to understand what is mediation, and third, train themselves as to how to look at the issues and the way the questions which we pose in the course of mediation can lead to problems. And this will be a major change, according to me. What I would say is, in the light of in the light of the statement which I made, that collaboration, peace and prosperity, when I was traveling from Delhi to Livingston, I saw a slogan somewhere. India today is having its presidency of G20, a group of 20 nations. There are few African countries also part of the G20. What attracted my attention was, I was just noting it. It speaks one earth, one family, and one future. This is nothing but a statement relatable to the existence of this universe because of climate crisis. This one statement is enough for us to all to unite, give up all the differences we have and try to promote peace. And according to me, mediation has come and given us a major concept for all of us to not only digest but also execute, and lawyers have a major role to play in this aspect. Thank you.
Thank you very much, sir. At this point, we'll take questions from the delegates. Please, in asking your questions, ensure to tell us your name and where you're coming from, and also ensure to direct your questions to a specific panelist. So may I see your hands if you have questions? You have a question? Okay, so we'll take yours and then we'll take hers. Okay, so please proceed.
Merci beaucoup. Ouais, je vais parler en français. Oh, je peux y aller parce que la question c'est pour vous. Hein. The question is for you. Yes. Voilà, merci beaucoup pour vos différentes présentations pertinentes. Nous avons beaucoup appris de vos différents développements et je suis totalement d'accord avec vous sur votre appréciation sur l'intelligence artificielle, qui est juste une intelligence artificielle, non naturelle, qui est d'ailleurs du fait de l'homme. Donc l'homme en tant que tel ne devrait pas avoir peur des changements. L'homme ne devrait pas avoir peur de ce qu'il a eu à concevoir. Donc c'est nous qui pouvons dompter l'intelligence artificielle et non le contraire. Et je pense que l'intelligence artificielle ne fera que faciliter le travail pour que ce soit les juristes, que ce soit les ingénieurs, que ce soit les agriculteurs, mais ne pourra pas remplacer l'homme en tant que tel. Moi, c'est ma croyance, c'est ma conviction. Le deuxième aspect, c'est par rapport à la médiation. Vous avez dit souvent, si je peux me tromper, que les États-Unis ont souvent utilisé la médiation comme moyen de règlement des différends. Mais les développements récents ont montré que souvent les États-Unis utilisent la loi Magnitsky, surtout dans les cas de corruption. Et nous l'avons vu tout récemment avec l'affaire Glencore, qui a fait débat au Congo, en RDC, en Guinée équatoriale, au Cameroun, en Côte d'Ivoire, au Soudan, Sud. Donc ce sont ces pays-là en tant que tels qui sont touchés par l'affaire Glencore. Et les États-Unis ne l'ont pas réglé par la médiation ni par l'arbitrage, mais ils l'ont réglé par les juridictions de droit commun, pour rentrer dans le droit. Donc ma question est, est-ce que la médiation fonctionne toujours dans les questions qui sont relatives à la corruption ou bien au détournement, surtout dans un contexte africain où beaucoup de pays ne bougent pas dans l'affaire Glencore? Thank you. Merci beaucoup.
Thanks for the question. I was telling you that every dispute that comes for this resolution, mediation is not the answer for every dispute. But what is important is, when it comes to question of corruption, we have legislations which deal with corruptions. We have the respective ways of dealing with this in respective jurisdictions. At the same time, when it comes to the question of identifying who is the culprit and what should be the punishment, it will go the way in which the act, the enactment of that particular country speaks. But when it comes to question of reformation, restorative justice as they call, there mediation can have a little role to play. Otherwise, law of the country will take its own course. By and large, that would be the way in which things happen. But I must also tell you, since you are referring to Cameroon, I know a lady justice who retired from the ICC, International Criminal Court, was based in Nairobi. She has been regularly traveling to Cameroon as a mediator to to resolve the dispute that arose between two sets of persons. One is Francophonian, the other is Anglophonian. So, mediation has been adopted. Probably the authorities, establishments have thought mediation must be the right method, and that's the reason why this lady, because when I was trying to interact with her, trying to bring her in one of these webinars which I was organizing, she said, I am currently engaged with this activity. So I was jocularly telling her, why don't you invite me also? So what I'm trying to say is, to resolve these kind of disputes, mediation has been used. Today, the world is witnessing the Ukraine war. Recently, I was in London, almost for a month, more than a month, where I witnessed, the one which I did not witness in India, I witnessed in London is the skyrocketing of prices. Anything and everything, the prices have gone up like anything. And when I was trying to understand, was it because of COVID? Or was it because of Brexit? What I understood is, it is more to do with Ukraine war. Recently, a bunch of countries from Africa, their leaders went to meet Putin. Question is what they were actually telling, what they were discussing. It was nothing but trying to settle this issue to mediation. They didn't use that word, mediation. But the approach, the entire exercise is nothing but trying to find a reason to solve this crisis in the interest of the community at large. Not only in the interest of Africa, the entire Europe is suffering because of the entire world is suffering that matter. In a major way it is Europe, and in a substantial way it is Africa, which is affected because of Ukraine war. So mediation has been adopted. Mediation as a concept might not have been used, but leaders of all these countries, bunch of countries, went to meet Putin. Of course, they didn't succeed, that's a different story, but otherwise attempts have been made, and it is continuing. And that's the reason I believe, even to solve or making attempts to solve the major problems across the world, mediation as a concept will be useful. Mediation has got its limitations. At the same time, in terms of resolving macro issues, mediation has got a great role to play. Thank you.
Thank you very much, sir. Can we have the next? Yes, please go ahead. That will be the last person. Please go ahead.
Okay, thank you very much. My name is Nyambura Mbatia. I'm the registrar of the Comesa Court of Justice. And my question goes to the professor. I wanted to find out about the place of mediation. Mr. Santan, the place of mediation in investor-state dispute settlement. Because in the earlier session, we were talking about arbitration. I have hardly heard about mediation in investor-state dispute settlement. Do you see a future where member states or countries and investors are going to be using mediation as a way of resolving their disputes? That's my question. Thank you very much.
Thanks for the question. Investor-state dispute is a major dispute which is occupied by this concept called arbitration. Arbitration is playing a major role. But I personally believe more than arbitration, mediation has got a major role to play. Because it is not disputes as such with regard to facts. When an investor is investing and there is a process through which it led to a dispute, everything is on record. In record to understand what exactly is the problem. Once you understood what is the problem and what is the hitch, it might be an ego of a person sitting at table A, table B, table C or table D. According to me, mediation can play a major role and not arbitration. Similarly, we also heard something to do with construction. In the mediation summer school which we are organizing from 22nd onwards, on the 8th or the 9th day, the lectures are on two parts. Two persons from Hong Kong are speaking. One person is concentrating on the Singapore mediation, and the second person, with regard to the modern tools, the notable things that are developing today, he is going to speak on the disputes concerning the construction. Construction is a major thing that is going on across the world, whatever be the type of constructions. And everywhere there is a dispute. And that person is going to speak on mediation in construction. So, what I am trying to say in terms of modern thinking as to how mediation as a concept can be used, construction, as I told you, is one field which I am going to deal with. I mean, not me, but somebody else is going to deal with. Investor-state relationship, there is nothing as far as disputing the facts, because everything is in record. What remains? Negotiation, discussion, and settlement. Mediation has got a major role to play. Thank you.
Thank you, sir. Let's have the last question.
Merci beaucoup pour la parole. Je vais poser deux questions aux deux intervenants. Premièrement, pour le professeur, je voudrais savoir quel est l'intitulé de la Convention de Singapour. Cette Convention de Singapour a été adoptée quand et quelles sont les conditions pouvant permettre aux États d'adhérer à cette Convention de Singapour? C'est la première question. La deuxième question est posée à Madame Peter Mumba. Vous nous avez parlé ok, sorry. Alors, vous venez de nous parler de l'avocat médiateur en Algérie. Ma question tente à savoir comment cet avocat médiateur est payé en Algérie et quels seraient les sorts ou quels sont les juges naturels en cas de contestation du paiement de l'avocat médiateur. Je vous remercie.
Thank you very much.
Thanks for the question. Let me clarify. It was in the year 2018, the United Nations passed a resolution for giving effect to the mediated settlements of parties across various jurisdictions. For example, if there is a party in Zambia and if there is a party in the adjacent country called Zimbabwe, they are in a business transaction, and in that process there is a dispute that arose. Whether you sit and resolve the dispute here or in Zimbabwe, it has to be given effect to in one of these places or both the places. Unless and until there is some mutual agreement between these two countries, it will be easy for one party or the other to not to give effect to that mediation by using cock and bull stories. If both Zimbabwe and Zambia sign and ratify this particular convention called Singapore Convention, then what happens is the dispute that was settled through mediation can be easily given effect to without any further dispute. In this question, which is second part of yours was with regard to Singapore. The significance of Singapore is it's a resolution passed by the United Nations, and this was at the initiative of the United Nations. Singapore just happened to be a place where all the countries got together and signed it. You might also ask another question. What is, once I sign it, everything is done. What is this ratification business? Right? The ratification business is mainly to do with what you as a country, because it is inter-country, you as a country, what are you doing, what steps are you taking subsequent to your signing this treaty, this convention, which means you have to come forward, bring out a legislation where mediation can become a part of the mechanism of dispute resolution. You have to frame rules, you have to bring law and deal with the situation so that what happens, whenever within the country or the example which we are discussing, all these things can be given effect to if there is a legal framework. Coming from India, let me tell you, today India has signed it. India has not yet ratified. What is happening in India? There is a mediation bill 2021. We are in 2023. It is still not passed by the parliament. When it was introduced in the parliament, because of what was debated in the parliament, that led to referring this issue to a select committee. They sat on this. They met the parties concerned in this field. After hearing all of them, all the stakeholders as we call normally, they submitted certain recommendations. All those things are being under consideration before a parliament. Once parliament takes a call and once parliament passes, then this will become a mediation act, maybe 2023 or 2024, whatever. So once this legislation comes into the being, that will occupy the field of all these disputes. But today what's happening? You can ask a question, are you not doing mediations? Yes, the answer is yes, mediations are done. Under what? If if settlement is entered into between two parties, under the Arbitration Act of 1996, there is a clause. And everybody utilizes that clause for a mediated settlement. And that's how it is happening. And I must also share at this juncture with all of you is, in every country, wherever I saw, there is some kind of a mediation board or some such mechanism attached to a court. Which means, what are the kind of disputes that they do? These are the disputes referred to by the court during the course of dealing with various cases to the mediation board for settlement. And most of these things are family disputes, which means dispute between the husband and wife. But when it comes to the question of civil dispute or a commercial dispute or investment disputes, it is almost absent. And that's the reason why, besides the state being involved, besides the courts being involved, we also have to encourage and see a day where mediation is also becoming part of a private initiative. Mediation organizations can be involved. All these things can happen when everybody understands what is this mediation about and how do we deal with this.
Thank you, sir.
Merci. Donc pour le paiement des médiateurs, le paiement va obéir aux mêmes règles que pour les honoraires. Seulement à la seule différence que maintenant le médiateur, les honoraires pour lui vont être supportés par les deux parties. Chacune, et ne pourront pas contester. Le montant des honoraires ne peut pas être contesté par les parties qui ont choisi le médiateur. Merci. Je vous ai répondu qu'ils ne peuvent pas contester. Ils ne peuvent pas contester. Ouais. Merci.
Thank you very much. Due to time constraints, we can't take any more questions. So we've come to the end of this session. And then please, the take home for today is, as lawyers, we should understand the concept of mediation and we should train ourselves accordingly. Thank you very much. Okay, just one word from Mr. Krishna.
Before we wind up, I will share with our moderator, madam, the details of the summer school on mediation. Apart from me, you can also meet her and then take the details. Thank you.
Thank you very much, sir. Thank you to our amazing panelists and to the participants. We thank you so much for good listening. Have a good afternoon.
Just one housekeeping announcement. For everyone who is a PALU member, we will be taking passport photographs for the membership cards next to the secretariat room, which is the holding room. After the reception, you go straight. During the break, the afternoon tea break. So for now, enjoy your lunch. Anyone without a coupon? Okay, I'll give you.